Good evening. I am Kristen Carpenter, a professor of law here at the University of Colorado, where I also direct the American Indian Law Program. And it is my honor to welcome you to the 66th annual Coen Lecture entitled Indigenous Peoples in a Changing Global Landscape. This lecture will be delivered by my dear friend, Dr. Albert K. Barume, who's the United Nations Special Rapporteur on the Rights of Indigenous Peoples. Before we begin, I'd like to acknowledge that we're convening on the traditional homelands of the Arapaho, Cheyenne, and Ute peoples, and that there are 48 tribal nations with historic relationships with the state of Colorado. I would also like to acknowledge our friends in the room from the Native American Rights Fund, the National Congress of American Indians, a number of tribal governments, UN experts, the Center for Native American and Indigenous Studies, and other partners who are here with us tonight. As a law school and university dedicated to public education and public service, it is important to us to work with all of you to advance self-determination and human rights in both education and practice. The Coen Lectureship at the University of Colorado Law School was established in memory of John Coen, a distinguished member of the Colorado Bar and an able public speaker. This lectureship aims to bring a prominent and distinguished lawyer, jurist, or scholar of law to deliver an annual lecture to Colorado Law's students, faculty, and alumni on a legal subject of interest and benefit to the profession. For work on this year's event, I wish to thank the law school events team, including Lindley Bell and Jusiline Cacavallo, and the American Indian Law Program, including Hannah Aders and Milo Salazar, for their just truly heroic work. I should also thank our partners at the Implementation Project, our joint initiative with the Native American Rights Fund, who are always with us every step of the way. This event is also co-sponsored by the Center for African and African American Studies at the University of Colorado. The format for tonight will be a fireside chat conversation between our law school dean, Lolita Buckner Inniss, and Dr. Barume. In terms of format, after the original back and forth, Dean Inniss will pull some of the questions that online participants have submitted by chat, and I think there are 100 of them out there, so greetings to the online world. And then we'll try to take some questions from the audience as well, and then you're all invited to join us for a reception next door in Betcher. In this room, Dean Inniss needs no introduction, but I will say just briefly that she's not only the law school's administrative leader, but an accomplished scholar and teacher in her own right. She's the 17th dean of the University of Colorado Law School. She holds the Provost Professor of Law and is also an affiliate of the Center for African and African American Studies. Her prolific body of work includes scores of articles and essays, as well as the acclaimed legal history book, The Princeton Fugitive Slave, The Trials of James Collins Johnson. She's also written, very importantly, on issues of membership and belonging among Indigenous peoples, and she's been a visitor to my American Indian Law class to talk in a very moving way about some of those intersections. We're very grateful for her support of the American Indian Law Program, our support of the Special Rapporteur, and the fact that she's been leading our delegation to the United Nations Permanent Forum over the last few years. Now turning to our esteemed Coen visitor, Dr. Albert Barume. He was appointed as the Special Rapporteur on the Rights of Indigenous Peoples in December 2024. And in that capacity, he's responsible for reporting on human rights violations against Indigenous peoples throughout the entire world. It's a truly sobering responsibility that often takes a lot of courage. These are violations that are egregious, but also often invisible because there's so much power that can subordinate and obscure them. And without Dr. Barume in this position, the situation of Indigenous peoples would be even more severe than it is now. And with the promise of Dr. Barume here, I think we can hope that things can truly get better. But he had a long history before assuming the mantle of Special Rapporteur. He has over 25 years' experience working on Indigenous peoples' rights at all levels. He's a national of the Democratic Republic of Congo and among the very first lawyers to work on Indigenous peoples' rights in the 1990s in Africa. He's been an expert on Indigenous peoples at the African Commission on Human and Peoples' Rights, and also led a team of African experts who provided support to African diplomats during the negotiations around the UN Declaration on the Rights of Indigenous Peoples, culminating in its historic adoption in 2007. He was also a senior specialist at the International Labor Organization and chairperson and member of the Expert Mechanism on the Rights of Indigenous Peoples. It was in this latter capacity that I got to know him when I served as the mechanism's member from North America and later humbly followed in his footsteps as chair. But I can say I learned everything from Dr. Barume about diplomacy and presence, academic rigor, and truly excellence in this field. Dr. Barume holds a PhD in international human rights law with a focus on Indigenous peoples from the University of Essex in the United Kingdom, and a master's degree in environmental management from the School of Forestry and Environmental Studies of Yale University in the United States. He's taught Indigenous peoples' rights in several universities around the world, including our own, thankfully, and has published numerous books and articles on these topics. We're extremely fortunate that Dr. Barume has made the University of Colorado Law School his academic home. He could have picked any university in the world, and he picked ours. Working with a team that includes Professor and former Dean James Anaya, Professor Christina Stanton, Milo Salazar, Hannah Aders, both graduates of ours, and students in our American Indian Law Clinic and program who are sitting prominently in the front. We are always honored to have Dr. Barume in Boulder, and especially so tonight. And with that, I give you Dean Inniss and Dr. Barume. Thank you.
Thank you so much, Professor Carpenter. It is such a tremendous honor for me to be here, for us all to be here in your presence, Dr. Barume. I think, as you just heard from the introduction, Dr. Barume holds one of the most consequential human rights mandates in the world today. Over the past year, he has engaged Indigenous peoples across Africa, Asia, Latin America, Australia, and North America, bringing their lived realities into global legal and political discourse with clarity and moral force. Dr. Barume's recent work centers on two foundational questions. First, what does it truly mean for a nation state to recognize Indigenous peoples? And second, how must states approach land rights, not as grants of benevolence, but as acknowledgement of the inherent rights that predate the contemporary state itself? These are not abstract questions, as I'm sure that many in the room will agree, and I'm sure you, Dr. Barume, certainly would agree. As you noted during a recent country visit, you heard from community members who said very simply, cutting to the heart of the matter, restore our dignity. At a time when the language of human rights is often invoked but not implemented, Dr. Barume challenges us to think carefully about self-determination, non-discrimination, environmental stewardship, and the future of democratic pluralism. Dr. Barume, we are so very grateful for your leadership, for your courage, for your insistence that Indigenous peoples are not peripheral actors in international law, but central ones. Dr. Barume, nous sommes profondément honorés de votre présence. Merci bien. So I'm going to start with my first question. You've described Indigenous peoples not as a demographic label, but as a human rights claim for justice. How did you come to understand the term in this way?
Thank you, Madam Dean. The microphone is on. We were told it would be on. It's really a pleasure to be here. Thank you for inviting me to this prestigious lecture. I was actually told it was a lecture. I didn't know it was a trial. I did not have to answer to questions, but really it's an honor to be here. Let me use this opportunity to thank the university for the support that it has been providing to my mandates as a special rapporteur. As Professor Carpenter said, it's a one-man or one-woman mandate. And I still don't, I was telling the students the other day that I don't know why the UN can actually decide to entrust an individual with so much. What I'm trying to say is absolutely impossible for anyone to discharge that mandate without support of institutions like yours and support from students and colleague professors. So really, thank you very much. And if I remember, your question was, how did I come to understand indigenous peoples as a concept that has, in my opinion, shifted. The concept indigenous people has indeed shifted to move from being, it was more or less an ethnic identity concept. Community would identify themselves or call themselves indigenous because they expect the other to recognize them as originating from that area, which can be a region, which can be a continent, it can be country. And that is really what most people still have in mind when they hear of indigenous peoples. But the concept shifted, mostly following the adoption of the United Nations Declaration on the Right of Indigenous Peoples. So it shifted from being like an ethnic identity-centered concept to become a human right concept. And when a concept becomes a human right concept, it means otherwise that it seeks to redress an injustice. It seeks to remedy. The concepts are no longer seek to put people into a certain status, because human right is not devised to give status. Human right is devised to redress, to correct injustice. So the question really becomes, what is that injustice that affect or affected community that self-identifies as indigenous peoples? In my report to the Human Rights Council, I really sought to start my mandates with these fundamentals, because it may look as it's trivial, but it's not that trivial. And states, particularly in many regions, are struggling to capture why they are under an obligation to provide special measures for certain section of their national population without looking as if they are putting them in a privileged condition. Indigenous people or communities that really self-identified indigenous people suffer from something very specific, which I will try to outline very, very quickly. And it's something universal that you found on the American continent, in Africa, in Asia. It is what I call in my report a high-grade racial discrimination. It is a violation through which the victims or their livelihood are dehumanized, considered as savage, as something uncivilized. But the purpose of that dehumanization is to dispossess those people of their land and annihilate their culture. So two objectives for which that high-grade racial discrimination is performed. That is a specific violation, because not every single one in Africa, not every single one community on the American continent or in the Asian continent can claim to have suffered that land dispossession grounded in that high-grade racial discrimination. The colonization was just a context, because people would confuse by saying that everybody who was colonized was indigenous. It was just a context in which that specific violation happened, because as we speak, that violation is still happening in contemporary time, in Asia, including in Africa. In Africa, you have communities that are seen by their neighbor African in post-colonial Africa exactly the same as savage, as people who cannot possibly own land. And the whole purpose of that dehumanization is for those stronger, bigger community to take land from that. So that's, Madam Chair, Madam Dean, what makes the regime so clearly how it has shifted the concept from being an ethnic-centered, identity-centered concept into a human rights concept that seek to remedy that specific human rights violation.
Thank you so much for that response. As you were speaking, I was actually recalling some of our comments last night, and I reflect upon the fact that in some of my limited reading, when you think about indigenous languages, especially those here in the United States, very often indigenous people, they describe themselves, and when you translate how they name themselves the people. The people. And so when you think about human rights, at the core of it is humanity, right? And I wonder, is that why, for example, there can be so many efforts at the dehumanization, that's at the heart of land dispossession? In other words, what comes first? Was it a desire for dispossession, or was it this inherent understanding of some people who look at others and say, you are not human, you are not the people?
I think it is an interesting question, because indigenous people were nations, are nations. And the very fundamental reason why the colonial states were so afraid of their culture and they had to dehumanize them is because they were nations. They were not just an aggregate of individuals with an identity, with social structures, with political organizations. So the dispossession actually, it was construed the way it was construed because those colonizers wanted to access to territory. Indigenous rights over the land and territory are sovereign rights. It's the equivalent rights that states have over land. And during the decolonization process within the United Nations, indigenous people expected the United Nations in the 60s to address their issue the same way it was thinking of addressing the decolonization of mostly Asian and African states. Unfortunately, once more, the United Nations failed them. And it is for that reason that the declaration grounds indigenous people's land right of the territory in the right to self-determinations. Because if you recall very well in international law, the right to self-determination is conceptualized in the 60s because it's a tool for decolonization. And if you recall, the decolonization process or legal framework within the United Nations was grounded mostly through 3 major resolutions of the UN General Assembly. One resolution on political decolonization, and another key resolution of sovereignty over natural resources and territory. And it's for that reason that common Article 1 of the ICCPR and the Covenant on Civil and Political Rights actually is the same copy and paste in Article 3 of the UN Declaration on the Right of Indigenous Peoples.
Thank you so much. Dr. Barume, I wonder, in light of some of your comments you've just made and your earlier work, how should states distinguish indigenous peoples from other groups without creating a hierarchy? Meaning, isn't there a danger that we will simply turn things over where the bottom becomes top? Is that a legitimate danger?
Yeah, it is a legitimate danger. In my first report to the Human Rights Council on recognition, I advise states, because indeed recognition is really, a state cannot possibly deliver on a right for which it cannot identify the right holder. It's impossible. So states must recognize and identify indigenous peoples as particular right holder under international law. So in my report, I give an advice to states to take 3 cumulative actions in order to fulfill the obligation of recognizing indigenous people as provided for under international law. The first action is what I said: a state should formally recognize the unique historical injustices indigenous people suffered from. It should be written in policies or in law or somehow, but it has to be legally recognized, describing, if I have to be explicit, saying I will be taking such and such measure on behalf of such group because they have suffered historically something specific, as I described. When a state does that, the state will do justice to those people and to itself, because it will actually prevent state from looking as if it was devising a privileged status. The indigenous people legal regime is crafted in the equality principle. It doesn't seek to put indigenous people above other social groups. It seeks to lift them up so that they can enjoy rights on equal footing. The second cumulative action I'm advising states to take is to formally introduce into their domestic legal framework international standard on indigenous peoples. It can be constitutional revision, it can be by act of parliament, but those international standards have to be introduced into domestic standard, because indigenous people's rights emanate from international law. They are not created by states. States have obligation to just introduce those rights in domestic legislation. Third action, as I'm recommending in my report, is for the state to identify indigenous people. And I'm not saying it because, one has to be careful there. We're not telling states that the state will now have the right to decide who's indigenous or who is not. Absolutely no. But as duty bearer, the state as a duty bearer in human rights, it is important that they identify clearly the right holders for them to be able to deliver on public services and so on and so on. And more importantly, it is a state obligation to protect indigenous cultural integrity. And in fulfilling and delivering on that specific obligation, states must protect indigenous people, including from pretenders. So people or other groups that would seek to identify themselves as indigenous people simply for the sake of enjoying that specific regime. So it is those three steps that, in my advice, fulfill that state obligation. And as your question goes, the state will not look as if it was building a privileged regime for a section of its populations. And it's for that reason that it really needs, as a state, to clearly communicate to the rest of the populations that this section of my population have suffered from something specific that not everybody has suffered from, and it's for that reason, so that they could enjoy rights on an equal footing.
Well, thank you. And I think following on that, and you alluded to this briefly, what is the role of self-recognition among Indigenous peoples themselves?
The self-identification, it's central for two reasons. And I do touch on that in my first report. If Indigenous people is a remedial regime, it makes sense to let the victim be the one to decide which legal regime would better redress the injustice. That's the fundamental, or the basis for the self-identification principles. There are Indigenous groups or communities or peoples that have decided for certain reason not to use the Indigenous people legal regime because they want to achieve an objective that would be better served by another international human rights regime. I'll give you an example. When I was working for the African Commission on Human and People's Rights, we received a visit of the Tuareg indigenous peoples. For those who, the Tuareg is a group of indigenous people who live in several countries in the Sahel region. And in Mali specifically, a section of those indigenous peoples had gone on an armed contestation against the Malian government. And they contacted the African Commission with the view to assessing which international human rights legal regime would suit better what they wanted to achieve. And when they came to meet us, the question was, obviously, what do you want to achieve? And as I said, no, we are this time determined to have a statehood. We want to become an independent state, which is at times they were calling the Azawad states. So there was this discussion whether the indigenous people legal regime was the best for them to achieve that objective. And after discussion, actually, it emerged if they wanted to achieve maybe the minority international legal regime would be more suitable for them. So the self-identification plays both the role of really giving back indigenous people dignity. Because one of the things indigenous people have suffered from throughout history and in numerous continents is other people deciding for them. It's as if, they don't know what is best for them. So that's the second reason the Declaration insisted on the principle of self-identifications, so that they can independently, freely, not only assess which legal regime they want to go for as the best appropriate measure for redressing the historical injustice, but also started to rebuild that, that principle of deciding for themselves.
Thank you. I want to talk a little bit about the idea of inherent land rights. Dr. Barume, you've emphasized that indigenous land rights are inherent, that they don't originate from state recognition. And I'm wondering, how do we understand the sources of indigenous people's land rights if it's not state granted? What's at the foundation of those claims?
because they are not really land rights. Indigenous people have territorial rights. The rights that indigenous enjoy over their land and territory are sovereign rights because they are nation. They are peoples. They are equal to states. And it's for that reason that actually their rights are mandatory on states. The rights emanate from international law. And it's for that reason, as I said, that indigenous people had hoped that the decolonization movement would, at the same time, address their issues. Actually, and I wrote this in my report, that the Cree people of Canada in the 60s almost opened an office in Zambia, in Africa. And they developed relations, discussions, because Zambia was in Africa, let's say, the capital where, the decolonization movement of Africa was really being like conceptualized, and all the brain were regularly meeting. The Cree of Canada had a representative in Lusaka in Zambia for some time, because they saw that connection between their claim and indigenous people. And there is a writer that I like quoting much. He calls indigenous people's issue a decolonization unfinished business. And it is for that right. I wouldn't say this at the Human Rights Council in Geneva. State will go after me. They will think I'm calling for state indigenous people to secede. But as an international human rights law, advisor, this is really the grounding of indigenous people's rights over their land and territory. They are not just mere property rights that are granted by states, proven by some sort of title deed, because there is no state with a title deed over its territory. There is no such thing in international law. So it's that parallelism that need to be established.
So given what you've just said, what reforms would follow from the sort of recognition that you are supporting? What can and should states themselves do in view of?
There are some states that have been taking some, I wouldn't call them good practices. As I said, the only legal reform that a state needs to take is to introduce into the domestic legislation the standard that provides or recognizes indigenous people as sovereign, as nations, as people with territorial right over their lands. And it's for that reason, actually, that you see certain states recognizing treaties or relooking into the treaty practices. It's a living proof that for a state to address indigenous people land rights, the venue is not the traditional property rights. It goes beyond that. The traditional property rights become a little small component of enjoying that bigger rights, which is sovereign rights over the territory.
Thank you. I want to talk a little bit about your recent country visit to Botswana. And I'm wondering, I'm sure that while you were there, much of what you've talked about, you were able to see it sort of in real time. But I wonder, when you observed political, for example, political challenges and structural challenges, how did that inform the kind of work that you're doing? I mean, specifically in the case of Botswana.
Botswana is a really, really interesting case. It's actually an illustration of what I've mentioned earlier, of that specific human right violation being live and contemporary in post-colonial Africa. I remember when for the first time at the African Commission, we brought this argument to African head of states that the concept indigenous people was traceable on the African continent because we had on the African continent section of certain nations that were considered literally as savage or animals. And for that reason, the other bigger tribe could not conceptualize that people could own land. Mm-hmm. One of those countries, actually, Botswana. Botswana, as many of you might know, is one of the countries in Southern Africa inhabited by the people known as San people, or some of you might know them as Bushmen people. Maybe you have seen the movie God Must Be Crazy. Has anybody seen the movie God Must Be Crazy? So it's really a country where the bigger Bantu African tribe, exactly the same way colonizer did on this continent, walked on this land and found mostly hunter-gatherers and nomadic pastoralists. And they decided this is savage life. How can people continue to live like wandering around and chasing animals? You know, these people are they're savage. These kind of things need to stop. And they convinced themselves that one, that livelihood was savage. Second, that you can't possibly claim as, customary land rights on territory you hunt on or on territory you just wander in. That only if you were like a farmers, land tiller communities that you could on the post-colonial Africa. And for decades, those communities have been completely sidelined, living absolutely invisible, as if they don't exist. The mission to Botswana was really an illustration. And if I have to put it in one sentence, I would say it is an illustration of how transformative, as far as indigenous people are concerned, can be when a country is governed by decision makers that strongly, fully understand the basis of indigenous people's claim. Because the current president who took power 1 year ago was an attorney of indigenous peoples. He had for decades been in court defending indigenous people. He lost countless of court cases, and he became president not by mistake, but just suddenly became president, for not me going into inside discussion. So I witnessed firsthand how political commitment can decide first to recognize that specific injustice and second to redress it.
I want to talk a little bit about climate transition and indigenous lands. And you've warned in the past that green energy transition risks replicating historical dispossession if it's not grounded in free, prior, and informed consent. So how do we prevent climate justice from becoming climate colonialism?
Thank you for that. My second report to the UN General Assembly, because the first one is to the Human Rights Council and the second is for the UN General Assembly, that I presented in New York in October, I did tell states that indigenous people's lands and territory are on high demand, and global high demand. That was my first member state were raising hand. Why? But before I said that, I did underline, and it's true, my previous special rapporteur have said this. Indigenous people now live on the last pieces of their lands and territories because they have been pushing back for centuries, decades. People grabbing and then pushing back, grabbing and then pushing back. Now they live in almost all the continent on the last pieces of their land and territories. And it's the reason indigenous people are now fighting more and more. Not as a war, but they're resisting now. Because there is no place to push back to anymore. They really are cornered now on last piece. So that's the first fact. It's a global fact. In Africa, everywhere is verifiable. The second is really the global high demand. And is driven, in my opinion, by 4 major factors, as I said to state. The first major factor are the transition minerals, most of which, huge quantity of it, are on indigenous people's lands. The second driver, and I decided to separate the two, are energy transition. The new dams, the biofuel, and so on and so forth, and the wind farms and so on and so forth. The third is by, again, a very noble objective to extend protected area to 30% by 2030. And I'm not saying these things are bad. You know, the transition minerals are not bad per se. The transition energy are not bad per se. The extension of protected area are not bad per se. But we indigenous people cannot pay the price again. Indigenous people have paid for centuries and for decades the price for many states to develop. They can't be paying the price once more of the green economy or green world, God knows. And I'm not against those things. The 4 factors that is really affecting indigenous people's land is that indigenous people's land are at the center of major geopolitical interest. Many indigenous peoples live on borders or across borders. Many indigenous nations actually live on 3-4 countries in borders. And Madam Dean, borders areas are the playing ground for drug trafficking network, for global network of migration, for armed conflicts, and for extremism. I mean, Al-Qaeda and the Islamic State. Before I was actually appointed as a special rapporteur, I worked for a couple of years as an expert for the UN Security Council on Mali. And in the Sahel regions, those indigenous land occupied by the Islamic State and Al-Qaeda's. So indigenous people are the first you come across in many countries when those groups cross borders. It can be, migrant trafficking network, this is the first groups they come across, terrorist groups, drug traffickers, migrant traffickers, act of armed conflict are indigenous peoples. And once they come across those indigenous people, they abandon far remote area, very little public services provided. So they end up appearing as if they were accomplices. Mm-hmm. And then the cycle starts there, where their states consider them as accomplices of enemy of states, and the cycle of criminalization goes on. So those factors are making indigenous territory. I mean, the last case of Greenland is an illustration, really becoming a center, not only of those drive for, transition and climate change, but at the center of incredibly international security issues. And that's a challenge, that the new challenge that indigenous territory and land will continue to face.
So given those remarks, you in the past called for a paradigm shift, urging nation states to see indigenous peoples as partners in security, as opposed to, as you said, accomplices or threats themselves. Is that shift urgent?
That was my call. The conclusion of my report in New York, I said to states that they are missing on an opportunity. And I might be wrong, but let me say what I said in my report. I think indigenous people have a traditional knowledge that is absolutely essential for international and national security. Let me give you an example, Madam Dean. As I said, my former job with the Security Council, we would do some investigation on, there is a huge quantity of cocaine that comes from Latin America that lands in a number of African countries on the bore of the ocean, and that those quantity, for them to reach Europe, cross the Sahara Desert. You cannot make 10 meters or 100 meters in the Sahara Desert if you're not guided by an indigenous Tuareg. You cannot. You will get lost, and in 2 days they find you dead. So they make business out of convoying those things. It's an incredible traditional knowledge. I found the same, I was in a mission in Panama recently. I mean, it's the same on migration traffic, migrant route. What I'm trying to say, Madam Dean, and I said this to states, that why don't you make indigenous people your first line of defense? Because that's what they are naturally. When all these traffickers cross borders, the first group they come across are these people. And then, these extremist groups, these trafficking networks subsume those indigenous people, and some ends up being maybe involved. And this happens because states have taken the wrong approach of not partnering with indigenous people for national and international security. And instead, they leave those indigenous people isolated, not provided with public services. So little presence of state on those areas, making them vulnerable to those groups. And once those groups comes, they are labeled enemy of the state, accomplices, and so on and so forth. I think there is a huge potential in terms of international security and national security if states shift the paradigm and really partner with indigenous people for security issues. And in my view, it is a win-win situation because it's also for indigenous peoples an important element of self-determination. Self-determination includes absolutely security dimension.
Thank you. So Dr. Barume, I want to ask you a question that sort of comes out of my own self-description as a futurist, and some of you in the room have heard me describe myself that way, meaning I very much look to the past. As a legal historian, I am certainly very present, but ultimately I think it's the future that counts. And I think sometimes there are reasons to be hopeless. Do you see a future of hope for Indigenous people around issues like self-determination, around issues like dignity? What does the future look like? What does the best future look like?
Yeah, that's a massive one. I said somewhere recently, because I also said that I'm discharging this mandate in a really very particular global context, that I wouldn't, you all know here is incredible pushback on human rights, almost, contesting multilateralism. And some have said that actually the rule-based international order is over. I don't share that view. I don't share the view. And this is my take answering your question. I do think the principle, for me there are 4 principles that has been sustaining humanity, the 8 billion human beings on Earth, to make us live together as one family. Those are like fictional principles put together after the Second World War with the view to preserving that humanity should not go through that again. They might look fictional, but those principles have really kept the world what we know. So you have the equality principle. It applies for both state and individual. We have the non-discrimination principle. We have the international friendly relations, and you have the self-determination. These, in my view, are the pillar of international order. Why, whether you're born in Africa or in Japan, or this is what have kept the world together for 70 plus years. I think we have taken the stability for granted. And that's what I see as an opportunity in the current global context. Because for me, those principles have not collapsed yet. My opinion. Those principles have just been shaken, maybe seriously shaken. But they have not collapsed yet, in my opinion. Because if they collapse, what we're seeing will be multiplied by 100. What is good really, and that's the opportunity, is that at least today, everybody can see a glimpse of what the world will look like if those 4 principles were to collapse completely. And that's my hope. It's really an opportunity, the time we are passing through, because those who have taken the stability, the world stability for granted, today, everybody knows that it cannot be taken for granted. But they have not collapsed yet, and that's why maybe we are still sitting here. And that's my hope now, my really hope. This is what Indigenous people have been saying all these years. And those main lessons I think Indigenous people can give to the rest of the world. But people will always be different. We are 8 billion on Earth of different race, of different color, of different culture, of different livelihood. So there has to be some unifying, some gluing principles that keeps us as one family. That's, the first article of the UN Declaration, the United Nations Declaration, really showing humanity as one family. That's my hope. And I'm sure today everybody can agree that there is no other way than the 8 billion living together. And for that to happen, certain principles, maybe those 4 have to be, we find new ones, but it's a generational responsibility for our generations. Maybe the ones that Roosevelt and the other one put in place in 45, maybe they're too old, but there have to be new ones for us, 8 billion, to continue living. And that's my hope. Thank you.
Thank you. We're coming close to the end of our time. However, I wanted to draw a question that was submitted by one of our audience members because I think it's very apt given our setting. And that, Dr. Barume, is given all that you've discussed tonight, what is the role of the university? What is the role of a place like Colorado Law in helping to enact the vision that you just described?
Wow. Is it mine, that question? Okay, I think it's really linked to what I've just said. I think universities are more than before important. Because, and I have said this, I think what the world has to be tomorrow need to be decided by the youth. I find it really that, we, the old generation, are again trying to shape what the world should look like in 60 years, in 40 years. I think that's what really is the role of the university, to continue keeping that flame alive. That flame that makes the 8 billion, of us, sharing one planet and, feeling for one another. Because I think the climate change and all those risks are showing there is no way. Nobody's going to have their own paradise. Nobody's going to have their own paradise. I know people might go to Mars or to other planet, but the majority will be living on this earth. So there has to be some compromise. There has to be some common ground. And I think really I see the universities as those, only few remaining space where we can continue to do what we're doing here, meaning, thinking freely and just saying whatever we think. That's my take. But that wasn't just my question. I think anybody can have a go on that one.
Professor Carpenter, do we have time to take any audience questions?
I think we do. The audience is still quite attentive, if not rapt. Thank you, first of all, Dr. Barume and Dean Inniss, for the incredible tour. And I was just writing down all of the countries you mentioned. I could summarize the list, but I'll wait for a moment. Could we invite maybe one or two questions, and then we'll adjourn to the reception? Sunoe. Your remarks. Oh.
Even better. Thank you so much for your remarks. I know you can't disclose any of the particular facts, but I was wondering if you could give us a general sense of the kinds of claims or complaints you're receiving from Indigenous peoples in the United States.
Wow, that's okay. Thank you, Sue. Thank you, Sue, for the question. Actually, you just reminded me something. Because of the particular context in which I took the mandate, I decided to do something that none of my predecessors did to the mandate. I decided to create regional teams of lawyers. I have regional team working in Africa, like 2-3 lawyers, same numbers of lawyers for Latin America, Indigenous lawyers for Asia, and I'm forming a 4th legal team here that will look after the world. So the reason I'm doing this, Sue, is we're no longer in a global context where, as a special rapporteur, I would just say, it's outrageous, international law has been violated. That's what we used to do. And you expect state to feel, compelled to do something. That era is gone. International law means almost nothing now. People actually laugh at it. It's like, international law? What do you mean international law? I think the only real way today is Indigenous people have no other option than standing their ground. And I said this to my team. The only way out of this is Indigenous people standing their ground. So what can a mandate like a special rapporteur do in such contexts. So for me, creating regional team is really to create a team that indigenous people can feel is in proximity. So bring the mandate more closer to indigenous people so they can feel at least that there is some support in proximity. In terms of compliance, I mean, you know, indigenous people, and that's why indigenous people are particularly vulnerable in current context, because they're already suffering from prejudice. They've suffered from prejudice, and the era we are in, it's an era built on prejudice. So that's the ideology. When you try to rank people and so on, and so it's grounded really in prejudice. And I actually had to make a press release. I had to make a press release recently, which is public now anyway, just to illustrate. Because some influential person in these countries said something like, you know, they should have killed more Indians, something like that. Yeah. As a special rapporteur, I had, and I wrote in that public press release, that is absolutely shocking, the level of regression. It is as if there is no longer anything that cannot be said. And if that is the world that we have to live in, indigenous people will really pay maybe twice the price. So I think the hate speech, just to respond to your question, the hate speech, prejudiced opinion is increasingly coming from different states. If you allow me not to name a state. Thank you, sir. Thank you.
Perhaps one more question from the audience, and then we will conclude. Yes. The microphone is coming.
Thank you. Dagote, Sky Roosevelt Morris on say. My name is Sky Roosevelt Morris. I just want to thank C. Boulder and our distinguished guests for presenting this evening. It's an honor. I just had a quick question about the UNDRIP in its entirety.
Yep.
Don't you think that the UNDRIP itself is regressive towards the advancement of indigenous people's rights? And because you opened with talking about indigenous people's rights and then how it has transitioned because of the UNDRIP to human rights. But indigenous people's rights are not human rights. Human rights are individual rights. Individual peoples, or indigenous peoples, thus the S on the end of people, and I know you know this, you're an international scholar, that is very specific and intentional to designate collective rights to peoples and nations. And, you know, talking about the best that we can hope for is to be pawns for the international and national security of invader states. Like, I don't think Tona Odom people would appreciate that, being used as pawns for the United States and Mexico. And who are we to judge other people in their advancement for self-determination? If people have to pick up weapons, if people have to sell opium to advance their struggle for self-determination when they are facing multi-billion-dollar, multi-trillion-dollar invader states. And so to me, the UNDRIP is a regression of the advancement of indigenous people's rights. And it's a cul-de-sac for the advancement of indigenous people's rights. None of those recommendations ever actually amount to anything. The declaration itself is not even a legally binding instrument, if we're just being 100% honest. And so I'm really curious to hear, because I've heard James Anaya say it. I've heard countless special UN rapporteurs say the same thing. But to me, as an indigenous person, the UNDRIP itself is not doing what it's supposed to be doing because of Article 46 that says not Article 3 of self-determination. None of it matters, because any aforementioned article as long as it calls into question the territorial integrity of invader states, is null and void. So what kind of declaration, what kind of hope is there when that's the final article of the UNDRIP? Thank you, sir.
That's an extremely tough one. I'll try to I'll start with first, make 2 points. As the first point is that and I agree with you, the UNDRIP does not create indigenous people's rights. It's not UNDRIPs that create indigenous people's rights. Indigenous people's rights have existed in international law before the UNDRIP. It's a right to self-determination. It's a right recognized to nations since international human rights law exists. The UNDRIP is a reformulation of, to capture, and that's my second point, to actually introduce into human rights is one of the keys that introduces into international human rights law collective rights. And by the way, the self-determination right is a collective right. It is a collective right that states enjoy. That's my first point. It is a practice in international human rights law and international law to, when you read, for instance, take an example, the Convention on the Rights of the Child, the Convention against any form of discrimination against women. There is absolutely no new rights in those conventions. The existing rights are reformulated to capture the specific conditions of women, of children, of persons with disability, and so on and so on. It's a practice in international law. It does not mean they're creating new rights. Your question about the reading of Article 46 and 3, whether the provision in Article 3 is diminished by the provision. That's your question, I think you're asking, whether it's diminished. I don't think so. I think anybody who would reach that conclusion is really a complete wrong interpretation of international law for mostly major reasons. You know, the principle of right to self-determination as enshrined by the common article of the Convention on Political and Civil Rights and Economic and Social and Cultural Rights is the very same rights reproduced in Article 3. The Article 46, the content of that article, if you read most convention, you are likely to trace down those kind of provisions. They are final provisions that exist in most conventions, in most international instruments, that connects the new instrument to existing international legal frameworks. I am from the civil law system, a French civil law systems. That category, for those who write laws here, know that the last section of any single law, they call them dispositions transitoires. They are provisions you put into a legal text to connect that new legal text to pre-existing legal text. That's a practice in all international instruments. You read every single convention, the end provision. It's actually a good, let me be honest with you. It was actually a good trick that indigenous people played Africans during the negotiation of the declarations. because, because it's the African group who was pushing for Article 46, actually. There was a sentence in Article 46 that was supposed to be a second paragraph of Article 3. That was the demand of the African states. The indigenous people, some sitting in here, and I remember New York, really pushed back too hard to convince African states that there was no need to have a second paragraph to Article 3, that they will take that sentence and put it in Article 46. And Africans, they fall in a trap because it's a legal trap. By taking that provision in what we call the disposition transitoire, it actually does not make that provision a substantive provision. I'm not sure, you're following me, right? So there is there, again, if I have to, but let's go, you might want to read, we actually wrote an article on the declaration where we want to, on more detailed on this, you might want to consider to read. But you're absolutely right. The UNDRIP doesn't really create those rights. Those rights are pre-existing, so it don't have an effect at all of diluting or whatsoever it can do on indigenous people's rights. Second, the right to self-determination for indigenous people is an intact right. Is absolutely intact right as provided for in Article 3 and Article 4.
Thank you, Dr. Barume. And I'm reminded, going back to the other question about the role of the university, this is the role of the university, to have spirited discussions like this about difficult legal issues. I can't help but make one comment on my own view about the declaration, which is that it's a living instrument. It is up to every single person in this room to make it live and breathe indigenous people's realities and worldviews. It has rights and responsibilities. It has relationships and duties. And it has explicitly, as Dr. Barume said, individual and collective rights. And my students here and others I know are working incredibly hard with the leadership of those who have gone before us, like Dr. Barume, to make all of that meaningful in the lives of indigenous peoples. So please join me in thanking Dr. Barume and then joining us at the reception.
Thank you.
Thank you.